Okay, I think we should get started. I know that people are still joining us, but no need to punish the prompt people among us. Thanks to everyone who is joining us for this webinar on the consensus statement on HIV treatment as prevention and criminal law reform. I'm Catherine Hansons. I'm the founder and executive director of the Center for HIV Law and Policy. I will be mostly moderating. Our key speakers are the fabulous Bruce Richmond, who is the founder and executive director of Prevention Access Campaign and the launcher of Undetectable Equals Untransmittable campaign. Kate Bolton is a CHLP staff attorney, and she is our legal point person on state anti-criminalization efforts. We're going to cover the purpose of the consensus statement, how it got started, and its relationship to state advocacy on HIV criminal law reform. For you seasoned webinar participants, as you know, you're going to be in listen-only mode, but we are going to reserve at least 20 minutes, 25, maybe even a half hour of time at the end of the slides for questions. You type them in, and we see them and respond to them. So, to get us started, what we agreed, what we realized is that there really isn't any disagreement among any HIV advocates that we're working with, regardless of the area, about the remarkable transformation of treatment of HIV and what it means to be living with HIV, not only in terms of life expectancy, but also in terms of how infectious a person living with HIV might be. So there's no disagreement there. One of the reasons for beginning conversations around the consensus statement is that at the criminal law reform level, among grassroots advocates around the country, there really has been mixed views about how best to use the relative miracle of HIV treatment take that science and incorporate it into HIV advocacy related to criminal law reform. So in some places, folks are wondering, should U equals U be an explicit defense that we incorporate into the law? Does it make sense to include viral load and effective treatment as somehow related to risk level or intent in a criminal law? Others have raised concerns that big disparities in the reality of current care access could really translate into increased disparities in those same people's legal options and outcomes if we focus too much on treatment and prevention in our arguments for reform. And the concern there also is that the people who are disproportionately targeted already are the people that have the most to lose in anything that might focus on or inadvertently make an issue about access to care and response to care. So, one of the things that I think is really important, regardless of where anybody is on the U equals U campaign, and as Bruce will make clear, the endorsement of that has been huge. And one of the reasons, the reason is that a combination of incredibly simple, powerful messaging and graphics and the needs and the importance of those messages to people living with HIV really transformed into really an international movement in a relatively short period of time. And what that tells us is that choice of words, message, and a shared vision really do matter when we're talking about success in any advocacy campaign. But I think also not only at CHLP, but with the other 9 partners with whom we were originally, who were the primary partners, and the many other people with whom we discuss this issue, I think most of us believe that there isn't any need for treatment and prevention campaigns, whether you're talking about access, where you're talking about the empowerment impact of U equals U, whether you're talking about just basic literacy in the science. None of that is or has to be viewed as in conflict with HIV criminal law reform, and there are critical reasons why we need to search for common ground and take special efforts not to work at cross purposes. The other thing that we know from working with some remarkable advocates across the country is that a single model law really isn't going to be realistic. Each state has a very, very different legal and regulatory schemes, and you're not going to be able to sort of jury-rig a specific word-for-word statute from one state into another, but we can share principles. That was the idea of the Positive Justice Project principles, and really the purpose of putting together this consensus statement. You don't need to be a lawyer to advance criminal law reform, but you really do need to understand what the current law is and what any kind of change is going to mean for anybody that's affected. So it's all about looking at the long view and getting the big picture. The purpose of the consensus statement really was then to illuminate the issue, propose some big principles, serve as a resource, and it's really, at the very least, getting people to talk about something broadly is, I think, always a good thing. So without further ado, hopefully, I am a Neanderthal when it comes to this technology, so forgive me in advance if I mess this up. But we're now going to move to Bruce to give some critical background on what the U equals U campaign is about. I'm going to try to toss it over to you, Bruce.
Okay, thanks, Catherine. Can you hear me okay?
Perfectly, but I can't see your slides yet.
Okay, it should come up in 1 second. Do you see it now?
No. Did you hit share screen?
No, I did.
There you go.
Okay. Okay, great. Thanks. So, I'm Bruce Richmond. I see a lot of our friends and colleagues are participants. I'd love to say hi to each of you if we had the time. So a blanket hello to everybody. The campaign is called Undetectable is Untransmittable, and it was based on the concept that we are in a defining moment in the history of the epidemic. In 1996, we learned that treatment would save our lives, and now we know that effective treatment also means that we can't pass on HIV to others. So that's what U equals U is. It means, more specifically, when a person living with HIV is on treatment and has an undetectable viral load, the person cannot transmit HIV to a sexual partner. And for the purposes of this campaign, undetectable viral load it's synonymous with viral suppression. So it's under 200 copies per milliliter, where undetectable is usually under 40 copies per milliliter, depending on the test and part of the world. So someone could have a viral load of 199 or 200, and they're considered untransmittable, really up to 199. Studies have proven up to that level, but it's likely that even up to levels about 1,000, 1,500, maybe even higher, are still not transmittable. And what treatment as prevention is a different thing. It's the foundation of U equals U, but TASC refers to using treatment to lower the risk of transmission, but it doesn't give a definitive assessment of how much it lowers that risk reduction, and it doesn't say the level of viral load required. So U equals U is more sort of specific and also more empowering way many feel to get this concept across. Why is it important? I think most people in the field understand that this improves the lives of people living with HIV in dramatic ways. We can have sex, we can conceive children without fear of transmitting the virus, and it's incredibly liberating in so many ways, and dismantles HIV stigma, which affects the epidemic on every level and affects all of us. So that's really pretty well known. But entering the field, I didn't realize, and even some folks we still talk to now are sort of learning that this actually affects every stage of the treatment cascade. So it affects people's willingness to get tested, to start treatment, to stay on treatment, and that's going to improve our health and also improve public health outcomes, fewer transmissions and lower community viral load. And then this is also, D is something that is also, I think, still a challenge for some to kind of process, in the sense that this actually helps people who are struggling with access for treatment. We're already seeing the preventative benefits, in addition to the personal health benefits, being used for treatment and advocacy, for viral load testing advocacy in regions in the global south. And this isn't something that I understood initially either. This is a sort of a learning process. So when we're going to policymakers, now we can say, we need treatment to save our lives and to get us closer to ending the epidemic, to stop new transmission. So if you want to end the epidemic, give us all the option to go on treatment and to get the care and the services that we need to become virally suppressed. So we're just going to do a quick overview of the science. This really started with, and as you know, undetectable is synonymous with viral suppression for all of these studies. It started with the Swiss statement with Pietro Vernassa, who's really the godfather of this campaign. He said back in 2008 what we now are confirming. And when he came out with the statement, with Swiss statement, that people who are on effective treatment are not sexually infectious, the world discredited him. But he had strong support within Switzerland from the Swiss Federal Commission for AIDS-related issues, and he stood firm in his conviction, which we now know is true. Then the clinical trial started with HPTN-052, where there was a 93% reduction in risk from early treatment and 100% risk reduction when people were virally suppressed after 6 months. So there were 0 transmissions from that study after 6 months with 1,800 couples. This was a science breakthrough of 2011, and the final report was published in 2016. So back in 2011, folks like me were learning that I could transmit the virus because I had a doctor that trusted me and was connected and to the well-informed medical and public health communities. That's not fair, and that's why we started the campaign, to make sure other people knew as well. Partner, probably a lot of you have heard about 58,000 condomless sex acts. This includes vaginal and anal penetration with ejaculation. There were no transmissions, and there were STIs, fairly high levels of STIs, and no significance to viral blips. Partner 2 is continuing to study men who have sex with men. Opposites attract. The final results were just presented at at IAS. 17,000 condomless sex acts, also with anal penetration, high STI rates, and 0 linked transmissions. So there's tons of data now. We have lots of data, not just these studies. There are other studies. Those are the most prominent ones. And also the non-observation of any incident occurring since the beginning of antiretroviral treatment. But why don't people know about this? So there was a recent study, and this is there's probably more awareness at this point, because this was based on 2014, that showed only that higher than 86% of people who are living with HIV and on treatment overestimate their infectiousness. So why didn't we know about this? So there are a lot of reasons why we didn't know about this, and this is actually a presentation on its own about all the kind of the gatekeeping that happened, and all the various types of stigma, phobias, and paternalism, and structural violence that occurs in medicine and in the HIV field that prevented all those studies on the left-hand side, and things like the Canadian Consensus Statement, which was released in 2015. And the Canadian Consensus Statement said that vaginal sex is negligible risk. So how many women living with HIV in the world knew about the Canadian Consensus Statement? That was over 70 infectious disease specialists in Canada. And the European AIDS Treatment Group from in 2015 released a very strong statement saying folks who are undetectable are not infectious and we need public health campaigns to get this information out. That was 2015. How many people knew about that? So there are a lot of reasons, but the main thing is really there wasn't a publicist for this science. There's lots of different independent publicists that work for the different departments that funded the studies and the various researchers. But there wasn't anyone kind of caretaking this very, very, very important message. So that's what we decided to do. We decided to get this message out to people. We worked with, we're really lucky to have found partners of organizations run by people living with HIV for people living with HIV that work with us in the very, very beginning. Positive Women's Network, Positive Light from Canada, HIV Modernization Movement, Carrie Foote, and Rise Up to HIV, Kevin Maloney from the very beginning were really important partners. So our first goal was back in 2016, about a year and a half ago, before the results of the studies came out, we started working with the researchers on a global consensus statement to confirm that it's true. And then the next step was just get that message out to everyone through partners. We don't disseminate the message on our own to every kind of person living with HIV from every geographic background and every various language. And we don't do that. We work with organizations that work with different people who can then communicate the core message in ways that work for them. So this was the consensus statement, and we can kind of move through this quickly, but the bottom line was the researchers agreed that it was negligible risk from someone. The key factors were they needed to be on treatment, they had to have an undetectable viral load under 200 copies per milliliter, and it's sexual transmission. This isn't through needle sharing or breastfeeding, and that actual adherence was important. And negligible negligible is no risk worth considering. So it's insignificant, it's not important. It's in the same category as biting, spitting, and throwing bodily fluids. And this was before, remember this was before the published studies were released. This was back in July. We issued a statement to coincide with the release of Partner and HP Tineophthalate, and this was before Opposites Attract. So what we needed at this time were influencers to stand behind this message, to stand up and say, yes, this is indeed true. So we were, again, really lucky to find some heroes and sheroes in the field, starting with New York City. The campaign was born here in New York City with Dimitri Daskalakis and the New York City Department of Health signed on to the campaign back in August of last year. Then NASTAD came on and Housing Works came on, and we had a firm, solid ground of organizations in New York. And then really with groups like Katie, San Francisco came on first in California, and groups like Katie and IAS and AIDSMAP and ICASO, they brought this campaign international very quickly. These groups felt that this was really important to sign on, make a clear statement, going beyond negligible, not because people don't understand negligible, but saying cannot transmit. Karen Siggins Trust, I should just mention, was the first organization globally to get this message out. So this very early on, we were lucky to partner with them. So since then, you know, a lot of these groups actually were early adopters too. We consider all these groups early adopters. After USCA, groups are going to be late adopters. But at this point, take a look at these organizations. These are just some of them that have signed on, and we consider these the groups that have stood up for truth and people living with HIV and around the world. Most of them found the campaign through someone living with HIV, finding us on social media through one of their networks. So essentially, this is pretty much run by the community, all people living with HIV. So at this point, we're at 356 organizations, 46 countries. The consensus statement was just translated into Swedish and Chinese last week and this week. And we have partners all around the world who are communicating this in ways that work for them, from groups from IAS to AIDSMAP to Red Ribbon in Istanbul, to the Taiwanese People with HIV Association, lots and lots of different groups. And you can see the way that they're messaging on our website. We have all their different social marketing campaigns. But now just to get to messaging, this is really important. The way language, as we all know, is critically important, and we need to get it right. So this is Carl Diffenbach's. This is sort of his famous quote from last August, that people who are virologically suppressed are not capable, that's very strong, not capable of transmitting HIV. They are no longer infectious. Infectious is a difficult, is a word that is stigmatizing, so we do try to stay away from that. Scientists like to use that still. And even Anthony Fauci was clear just recently that someone who is on treatment and has an undetectable viral load is not infectious. We can't say never, but it's so close to never, and there's an overwhelming amount of evidence in science that allows us to be confident that we can say uninfectious, or we can say cannot transmit. So we need to do that. If Fauci is doing this and Carl Diffenbach is doing it, we need to do this as a community. And this is one thing that we're imploring all of you to do, because HIV stigma is a public health crisis, and when you're careless, when you're describing the risk from a person living with HIV, you're being careless with our lives. Here are the sort of problematic words, phrases on the left, and the updated phrases on the right. So it's okay. It's okay to say the words on the right. It absolutely is. And we were actually really happy with Catherine and team for working with us to include that very clear language in the consensus statement. Now, why is this important? So it doesn't, you know, in our interactions with our own community and just, we've been doing trainings now around the world, there's a tendency to see this as the solution, as the main solution to criminal law reform, and it really, that could, as we know, that can be dangerous. So because it could create that dichotomy between undetectable and detectable, and subject a whole class of people to prosecution who unfairly may not have access to treatment, and are already being neglected by the healthcare system. And so we were really, felt this was important to be a part of the consensus statement, because our advocates, we needed guidance on this. And we know that, we've had conversations over the last year and a half, and with the folks in criminalization reform on this. And so I think this document is really helpful, that we have some place to send people who want to know how to use you in criminalization, and now we have a place, and so we're really appreciate it, and we're encouraging folks to pay attention. If anyone who works in U equals U advocacy needs to know this, because we get asked these questions a lot, and we don't want to present this as the panacea in criminalization. So if you want to join us, please, you can sign on to the campaign, and please remember that we need to fight the third U. It's unequal access, and the way we can use this to strengthen our advocacy for universal access to diagnostics, treatment, and care. So please consider it. Sometimes this isn't being used in treatment advocacy yet. People are really saying save our lives, and this is our human right to treatment, and we need to go beyond that and say, and it will help you end the epidemic. Really important. So show your support. Please sign on to our campaign. If you're an organization and you're interested, it really helps with to show unity, to be a part of this. I mean, we're doing pretty well in terms of numbers of organizations, but the more groups that can sign on, the better, and you'll be a part of our resource network. So there are a lot of, we provide you with the research and materials, and please also sign on the consensus statement. I think it's really important that we stand behind this, and that folks are at least aware of it, at least aware of this perspective on U equals U in crim law. And oops, that's it.
Bruce, thank you.
Did I stop sharing?
Perfect. Perfectly done. Thank you so much for that. That was really
You're welcome.
elegant and lovely. We're now going to turn to Kate Bolton, who will give a sort of thumbnail sketch of the larger issue of criminalization, and then drill down a little bit into the origins of the consensus statement on TASPN HIV criminal law reform, and then hopefully we'll have some questions. If questions are occurring to you now, you can certainly type them in and get into the queue so we can jump right to questions as soon as Kate is finished. So Kate, take it away, please.
Thanks, Catherine. And thank you so much, Bruce. I think that was a really fantastic overview of U equals U, and I'm hoping that everyone on the webinar has a strong sense of the current science and also the extraordinary momentum behind the U equals U campaign. I think Bruce's focus on the importance of precision in language is a good way to transition to what I'll be talking about, which is the relationship between treatment as prevention, or U equals U, and efforts to reform HIV criminal laws. So just as describing the state of the current science requires that we be careful with the terms we're using and our framing, the way that we use U equals U and HIV criminal law reform also needs to be done carefully and with a lot of precision. So I'm assuming that a lot of you participating in the webinar are already pretty familiar with HIV criminalization, but I also want to make sure that we're operating with a shared vocabulary. So HIV criminalization is very simply the prosecution and imprisonment of people living with HIV for things that are otherwise legal or are minor crimes for people who have not tested positive, such as consensual sex or spitting. Over 30 states and several US territories have these kinds of laws in place. Many states also use sentence enhancements for sex workers living with HIV, so that what would ordinarily be a misdemeanor solicitation offense, for instance, becomes a serious felony. And finally, a number of states also rely on general criminal laws, such as reckless endangerment or aggravated assault, to target people living with HIV for prosecution and imprisonment. So CHLP is actually in the process of updating this map, and the new and improved version is going to be released probably within the week. But this still gives you a good idea of how widespread these laws are and how much work we have to do to stop the discriminatory use of HIV status as a basis for prosecuting and imprisoning people. Efforts to modernize these laws are underway across the United States from coast to coast in states like Ohio, Tennessee, Florida, California, Georgia, Missouri, Louisiana, Indiana, and many others. Lots of you on the call are engaging in this advocacy, and we're so glad that you were able to join us. So, as Bruce described, the U equals U campaign was launched in 2016, so fairly recently, but since that time, with the increasing visibility and success of the campaign, advocates working at the ground level in the states have been discussing how U equals U can or should fit into their advocacy and education efforts. Some have understood U equals U as a sort of slam dunk rebuttal to the basis for HIV criminal laws, and as a sort of game changer when it comes to arguments about why reform is necessary. Others have cautioned that maybe U equals U does not directly and easily translate into the criminal reform context. So the consensus statement on HIV treatment as prevention in criminal law reform came about in response to those conversations with the hope that it could provide valuable guidance to advocates who are grappling with these challenges, namely, how do we incorporate new advances in treatment and prevention into the work we're doing to change these laws, but make sure the arguments we're using don't leave anyone out or undermine other important aspects of our position. So the thinking at the outset was that relying on U equals U as a sort of panacea, as Bruce said, could really pose potentially negative consequences for people who lack access to care. Drafting of the statement began in March with a small initial group of organizations and was followed by several months of intensive review, editing, and feedback. And that included folks working at the state level, it included national organizations, it included attorneys, but it also included people who aren't lawyers, because we felt that accessibility of the document was really important. The statement itself was launched in mid-July, so just about a month ago. When it was launched, there were 10 original endorsing partners, many of whom participated in the drafting process. You can see their logos on this slide, as well as on the website. Since then, there have been about 50 organizations, individuals who have joined, and we are hoping to see that number increase as awareness of the statement grows. So the thrust of the consensus statement is that reliance on U equals U as this sort of linchpin argument for modernizing HIV criminal laws poses serious potential and unintended consequences, particularly for people who don't have meaningful access to care. When we lead with the argument that prosecuting someone with an undetectable viral load is unjust and unscientific without saying more, we can inadvertently suggest that people who are not virally suppressed should be the targets under these laws, or at least that that's not problematic somehow. I think this is especially a danger with legislators who are often not that interested in the details and will latch on to what seems like a simple soundbite or easy solution to a complicated problem. The bottom line is that anything we pitch to state lawmakers in terms of modernizing the law shouldn't function to exclude the many people living with HIV in this country who are not virally suppressed, and who may also be more likely to experience prosecution under these laws in the first place. A second problem in centralizing U equals U is that it can sideline or obscure the importance of other key principles that support HIV criminal law reform, right? So we reject these laws because they discriminate against people solely on the basis of health status, and they continue to foster extreme stigma against people living with HIV. And so it's really important we don't lose sight of that when we talk about the implications of new scientific developments for criminal legal reform. Finally, these potential negative consequences of leading with U equals U in the criminal law reform context are likely to harm people of color and other marginalized communities who are less likely to benefit from sustained access to ART and subsequent viral suppression. So this slide sort of fleshes out that last point. We all know that there are extreme disparities in access to healthcare in this country, including when it comes to treatment for HIV. And those disparities mirror the forms of discrimination and injustice that we see in the criminal legal system, where people of color, particularly Black Americans, face more arrests, more prosecutions, and harsher sentences sort of across spectrum. And so if we build a law that hinges guilt or innocence on a person's treatment compliance or health status, that will inevitably interact with these two unjust systems, the criminal legal system and the healthcare system, and function to exacerbate harms against communities that are already disproportionately targeted and harmed under HIV criminal laws. So I've been talking about some of the ways in which relying on U equals U could lead to unintended consequences, in part because it can take away focus from other key arguments. You're probably thinking, okay, that all makes sense, but then what should we be emphasizing? What are the major problems with these laws? And what I think is key to understand, and what I'm hoping is one of the primary takeaways from today's webinar, is that U equals U and the growing recognition of treatment as prevention do not really alter what we already knew about these laws, which is that they have always been indefensible, right? The disconnect between the laws and the science has always been there. And we've been saying for years that it's outlandish from a scientific perspective to charge someone who spits or who has sex with a condom with attempted murder, or to argue that they even pose a real risk of harm to someone else. So you might be skeptical that people are actually suggesting U equals U should be the lead argument that we use to attack HIV criminal laws, but it's something I can tell you I've heard in my own experience, certainly. And we also see it displayed in a headline like this, which is a recent article in response to the opposites tract findings. as you can see, the headline suggests that treatment as prevention, viral undetectability, can operate as a sort of standalone or sufficient way of debunking these laws or defeating them and showing that they don't have an actual justification. But the problem with that is that, you know, what is it saying about all the other arguments that we've been making and that we need to continue making about why the laws need to change? So in our experience, the biggest problems with HIV criminal laws are the following characteristics. And I'm going to try and get through this pretty quickly because I do want to save time for questions. So first, unlike other types of crimes for harming someone else or risking harm to someone else, HIV criminal laws don't require an intent to harm. It's enough that you knew your status and you had sex with someone, which is a pretty low burden for a prosecutor. Secondly, HIV criminal laws function to perpetuate extremely inaccurate ideas about the routes and risks of HIV transmission. HIV is not easy to transmit, period, even without the benefit of treatment or using a condom. We know the per act HIV transmission risk of something like receptive anal sex, which is a sex act that is most likely to result in HIV transmission, is less than 2%. Third, something we see over and over again with prosecutors, judges, legislators, and others is, you know, language like calling HIV a death sentence and sort of strengthening the very stigmatizing idea that a diagnosis with HIV is physically and socially life-ending. But we know that with access to appropriate therapy, a person can live a long and productive life. And this links to the final point, which is that the laws impose extreme and disproportionate penalties. Oftentimes it's going to be felony punishment, years of incarceration, and potential sex offender registration. So Ohio is an example of a lot of these characteristics. Merely having sex or any kind of sexual conduct actually without disclosure of your status results in felony punishment of up to 8 years of prison time, potential sex offender registration. We're not seeing a requirement for intent or even conduct that poses a substantial risk. So if you want a model of a crappy HIV criminal law, there it is. So of course, what we identify as the problems also inform the principles that we've identified that need to be informing our reform efforts. So the Positive Justice Project guiding principles, which I think Catherine mentioned, lay out a sort of framework to approach HIV criminal law reform efforts. And as you can see, two of those core principles are that convictions should require a showing that a person intended to do harm and that punishment needs to be proportionate to the level of injury. So going back to both Bruce and Catherine's points, there really is no fundamental incompatibility between U equals U and HIV criminal law reform advocacy. The U equals U campaign is essential to reducing stigma and increasing support for HIV prevention and treatment access. Because it's a relatively straightforward idea and because there's all of this great campaign material globally available on it, it can be a really helpful conversation starter or entry point for people who are new to these issues. And even though the consensus statement opposes drafting viral detectability directly into a modernized law, that doesn't prevent it from being a tool in an individual criminal prosecution, right? So a defense attorney should still be using every argument available and representing their client. What we really want people to take away from the consensus statement is an awareness of these unintended consequences and a recognition that U equals U merely strengthens what has already been a powerful argument in our advocacy. So in the meantime, we encourage you to check out the consensus statement website. It includes a lot of useful resources. It also includes sample language of how we can draft laws that take account of the fact that someone may have been virally suppressed, but don't create a sort of separate defense just on this basis. You can also see the range of organizations and individuals who have endorsed up to this point. And we encourage you to educate others and spread the word. And with that, I think we'll move to questions. Thanks very much.
So thanks, Kate. That was fabulous. We do have some questions coming in. Before I turn to those and toss them over to Kate and Bruce, just one point that I think is really shores up something that Bruce was saying. And, you know, and it was in actually one of the slides where the CDC talked about, you know, mentions throwing bodily fluids as having a, quote, negligible risk. And in fact, it really should be zero. And one of the, you know, I think what Bruce is talking about illustrates the fact that in the history, decades of history of advocacy, whether it was related to treatment developments or how the CDC talked about disease, this promoting the actual science and getting public officials to acknowledge it has almost always come from community and from people living with HIV and NGOs that have pushed the government to tell the truth and to be transparent. It's only really recently that the CDC and AIDS.gov agreed to post information on websites that made any kind of distinction between different levels of risk in terms of potential exposure to HIV. So that's really key, and this is another example, I think, of where community has led the way and government officials have followed, and it's something important to keep in mind when we're doing advocacy all around. So to turn to questions, we have a couple here, and Mark King, wonderful Mark King, has raised a question that about how do we incorporate the U equals U science without making an absolute, that is, risking courts or juries using viral load alone. And another question kind of incorporates that, which is, okay, how do we do that? And I love those kind of questions because that's always that's really the big enchilada, okay, which is, all right, folks, tell us exactly how that would translate into actual language that you might propose for a statute. Kate, do you want to address that for us?
Sure. Yeah, I think it's critical that we don't treat it as an absolute. And again, I think we really need to think of it as just an additional tool within a set of arguments that we've already had available to us about the ways in which these laws are disconnected from current science. But I think the question about what this would actually look like in a law, so how do we translate that into draft language, for instance, we have an example of that on the website on the FAQ. And the language is, for example, measures to reduce the risk of transmission, which can include any method, device, behavior, or activity that limits or reduces the risk of transmission. Well, sorry, I'm just reading the definition. So it's essentially incorporating a broad and expansive definition of measures to reduce the risk of transmission, and then using that to say that a person who does any of those things lacks intent to harm, and also defining substantial risk of transmission narrowly and ensuring that that is also based on competent medical or scientific evidence. But the point is, you don't need to, you know, sort of myopically focus on viral detectability as a sort of operative question. You can build in a focus on the range of risk reduction measures that a person might take and which would have an impact on risk.
Right, that's great, really helpful. So I hope folks if folks listening in need further clarification on that or want to raise something related to that or offer other alternatives, that would be wonderful. But I think the key point is that there's nothing wrong with mentioning different ways to reduce transmission. You don't want to put actual health measurements necessarily as a determining factor for either risk or intent into a law. especially if part of what people are focused on is trying to get rid of HIV-specific laws altogether. And to where if we're going to cabin a way to deal with intentional transmission, that ideally it's not just focused on HIV, and ideally it includes some kind of big picture way of dealing with risk and reduction of risk that doesn't unintentionally throw anybody under the bus, right? So there are a variety of means that can show that you didn't intend to do harm, and that might include being on treatment. It might include a variety of other things. Let's see. What else do we have here? Someone in California says that there's a bill currently pending there. It's passed various committees and it's pending review by the Senate Appropriations Committee. I know that Kate's familiar with what's happening there. The inquiring person says, I read through the law and it includes the science of U equals U. What can advocates on the local level do to help push reform, and that would update laws that include U equals U, and also call for release of inmates currently incarcerated to HIV-related convictions? That's a lot of questions in one, and I would push back and say that it doesn't actually incorporate U equals U, but Kate is far more familiar with the details of the law. So Kate, you want to respond to that?
Sure. I mean, I don't have the language of the California bill in front of me, but I do think it attempts to incorporate, you know, a broad recognition of risk reduction measures that a person might take. I don't think it hinges on being on ART or having a particular viral load, which is the level of specificity that we want to make sure that we avoid.
Right. I think as far as releasing inmates currently incarcerated, that's a, there are some states, and Iowa is an example of that, where individuals who were on sex offender registries were removed from the registries, both proactively and people who had been convicted. However, people who were convicted under those laws are still imprisoned, and that generally is not something that you can accomplish through a statute, through the actual release of inmates, but certainly reform can make it easier to pursue release on an individual level through parole or reconsideration of sentence or other means. Bruce, do you want to jump in and comment on any of the questions so far, or anything you'd like to add on that?
Hey, okay, so like maybe the one on, I mean, I answered a couple questions. Let's see, maybe Christian's question down at the end.
Yeah, or whatever. I just wanted to give you a chance to weigh in if there was something.
Effectively zero. I'm trying to, so I think we actually do say effectively zero in the consensus statement, right?
Yeah. Yeah.
I think that's what we agreed. You know, we went back and forth on that, and then I think that was what we landed on. So I'm trying to see what.
Yeah. Let me
what's different.
Yeah. Let me read the question so folks that are listening in are. The question is, thank you. I'll cut through that. Let me jump to the question. Thank you for your thank yous, Christian. My question is, given that UNAIDS and International AIDS Society has officially recognized the science behind U equals U, would the drafter of the consensus statement reword the following statement? There is increasing agreement that risk of HIV transmission from a person living with HIV who is on antiretroviral therapy and has a continuously undetectable viral load is effectively zero, into wordings that recognize such fact. I think we agreed that that was in the zone of acceptable language. So.
Yeah, I think from a legal, that's sort of, yeah, it's on the boundary of acceptable, but it works. I think it does. I think in this statement, it works. I think with, in public health messaging, campaigns to everyday people outside of the field, that's not something that we would recommend. So Christian, I agree with you that in the context of our public health messaging, it's not something that we've seen or would endorse. But on a document that's in the legal realm, I think it works well. And I think as long that the main goal is to be able to convey that there isn't any real risk, so that a prosecutor or a judge couldn't say, well, any risk. We won't want to put anyone at risk, so any risk is still a risk, know that all we've heard that. And I think, Catherine and Kate and team, I think, felt that effectively zero would satisfy that, where, I mean, how do you feel? Do you think that prosecutors or judges would see effectively zero as and be able to say there's still a risk?
Yeah, well, but I like your point there, and I think, and this is where the difference between sort of zero and making life decisions and the terminology you use in courts and legal settings is very important. In a legal setting, if you say zero, any occurrence of a transmission, and I, that's an important thing to say. You can't be in a legal setting. Zero is taken far more literally, and any conceivable possibility, or if there was a report of a transmission someplace, somewhere, places a problematic dent in the argument, and it's also part of the argument that, first of all, it shouldn't have to be zero. It doesn't have to be zero for it to be beyond criminal legal reach. That's part of the argument that advocates make. That's part of the argument that we make. That you don't have to say zero. You shouldn't have to say zero. The issue is it substantial? Is the risk substantial? So effectively zero is way below substantial and is enough. And we don't, I think in the legal setting, we don't want to promote the notion that in order to be safe from prosecution, you have to be able to show or maintain that you have no risk, you pose absolutely zero risk of transmission. It's an unfair standard, it's an inappropriate standard, legal standard, and it's not one you want to see applied to any infectious disease. So that's kind of the reasoning there.
Yeah, and I think Christian just brought in another perspective. And I think, well, first, just to go back to the zero, if you do need to prove zero or you do need to show zero, you can always go to, AIDS map. NAN AIDS map said there's no infection risk, or Carl Dippenbach said there's zero risk. There are other groups that say zero risk that have credibility and have the sort of the research behind them. But Christian said that could you take away there's increasing agreement and say something more definitive, and I see actually what you mean, and I think that would make sense. The increasing agreement does seem a bit weak, and that's not something that I noticed when we were going through this, but it was a couple months before, it was before UNAIDS and Fauci's statement. Is that something, I don't know if there's possibility of still strengthening that a bit.
Well, it's actually, I'm sort of smiling here with Kate that there are requests for changes in the language on the consensus statement. I think, and one of the things I want to just emphasize is that it is a, quote, consensus statement, and there were a number of people involved in the drafting. It went through lots of different, thumbs up and thumbs down processes. So I personally can't answer it. I mean, I think, I don't know. you know, I'm not sure that there's anything that should be beyond improvement, and I'm sure that's a possibility there. It's always something we can talk about, but I'm not sure. I'm not sure we can work that out here, but I do appreciate.
Okay, yeah, let's talk about it. We'll talk about it afterwards at drinks. But there's another because I have seen that language. Yeah, we have much stronger language, especially the last couple of months that have come out on that. But I also am not as concerned about this. This statement is more about we're more concerned about public health bodies and public the messaging they're coming out. But it would be great to I think to address that. And thanks for the comment, Christian. Should I address Randall's question? Do we have time?
Let me see. Sure thing. I think we have about 2 or 3 minutes left. I'm supposed to be watching these questions, and I didn't do any less than stellar job. But go ahead.
Okay, so Randall, we hear this every day, and there's still a great deal of pushback all over the world, and I think what we found is helpful is to use the statements and flood people with statements sometimes from the leading organizations in the world, from International AIDS Society, from AIDS United, from Housing Works, from Planned Parenthood, from APLA, from, they're all Katie in Canada, from AIDS Map, from UNAIDS, so it's hard to argue with all of them, when and people, there is name recognition with a lot of these groups. So show them these very clear and easy infographics, and you can get them and pull them off of our site. And it's just going to take time. You'd be surprised at the extent to which people will go to keep people with HIV stigmatized, especially in the gay community. And so it's just going to take time to chip away. People will look at face the facts, we've been at seminars where someone will absolutely be staring at the AIDS map logo infographic on a screen saying no infection risk, and the person saying, but how can you say it cannot transmit when there's still a risk? We're like, why don't you, how can you disagree with the world's leading scientists? So it's a process. Just keep chipping away and go to our website, u=u.org. And there are lots of different resources, videos, radio programs, infographics, research studies, and I hope it's helpful. You can also find me on Facebook and message me there, and I can give you some examples too of ways to help.
We're now at 3. I wish there are some additional questions that were raised here that I wish we had the time to answer. There's one from, I'm going to try to combine a couple from Dorian and then Alexander in Louisiana. And because he pointed out that, sort of raised the issue of how do we avoid getting into the weeds and the problems of flexibility of legislators. I guess part of it is, yes, I mean, the best statutes or the best proposals are those that keep things simple as possible. But I guess part of the other answer is the importance of really sussing these things out before, going forward, and really making sure you've considered all of these things. If you want to add to that?
Yeah, I mean, I see it's always a challenge to avoid getting into what seem like very kind of inaccessible or esoteric conversations, especially when you're communicating with legislators. But at the same time, these kinds of questions are really essential to work out and can't really be dismissed or oversimplified. So I think
yeah, and
it's not an incredibly satisfying answer to that question, but
yeah, and somebody did ask the question about how important is it for the CDC to be on board with these things, and I think in part the answer is, I think both Bruce and I sort of indirectly address that, which is it's important, but we can't the public health officials, elected officials, appointed government officials tend, on the whole, to be far more conservative in what they are willing to say than are independent scientists and physicians. The response to the woman doctor who went and volunteered to treat Ebola and how she was quarantined when she came back is not a bad example of that. So I think that's part of why some of the leadership and has to come from people outside of government.
And even if CDC were to officially endorse or express U equals U, that wouldn't be sort of dispositive in like a legal proceeding. I think the question asked was saying, what would this sort of have specific legal implications? So
Right.
certainly it would affect the arguments you'd be making, but of course we know that people are prosecuted, even today for activities that the CDC has, unequivocally described as posing negligible risk, which, as Bruce said, means not worth considering, right? So it's not, those as normative sort of guidance, it's very important, and sort of building on the awareness and acceptance of U equals U and the science behind it. But in terms of what it means in a courtroom, a little different. But
right, and it's also important to know that what you're talking about, the risk, what the risk is, not numerically, but what is the actual event that is risked. Until we increase the focus on what treatment means for the person living with HIV apart from prevention, we're going to continue to have a problem where, however low the risk, it is too large, because people continue to see HIV infection itself, when it occurs, as a life-ending experience, and we need a lot more focus on that. And I guess, I'm sorry, but with that we have to wrap up. Thank you to everybody who joined us. We will make sure that the slides are available. They will be on our website. My guess is they may be on Bruce's website, and if there are additional ways we can make them available, we'll make sure that the folks are alerted to that through the same ways you learned about this webinar in the first place. So thanks again. And any other questions, of course, you can direct to
any of us.
Any of us. Thank you for finishing my sentence. Take care, folks.
Bye. Thanks for having me.
Okay.
Really appreciate it. Okay.